Welcome to A Lawyer's Guide to the Galaxy, a podcast about geek culture by lawyers with your hosts, Ben Siders and Kirk Taman.
And welcome back to A Lawyer's Guide to the Galaxy, the podcast that asks interesting questions that don't have any answers with your host, Ben Siders. That's me, and the other guy is Kirk Damon.
That's Kirk, as in the gaps in the enterprise.
We are intellectual property lawyers and certified geeks practicing law in St. Louis, Missouri. You can find me, Ben, on Twitter at Benjamin Siders. You can find Kirk at KirkDMN, and you can find this podcast at LGGPod. We are coming to you today. What is today? Today is June 17th. I mentioned that because we are actually recording several weeks ahead, amazingly enough. And we both have vacation time coming up in July. If things stay true to form, you should see no interruption in content. We should have stuff that will be published during that time frame. So hopefully that works out. But I also want to mention it because things are happening in the world. And since we are now recording on a sort of delayed basis, I think it's helpful to know when we recorded. So if you're like, why aren't they talking about XYZ? Well, that's why.
Yeah, because we're going to talk about it in a couple of weeks because we haven't actually recorded the episode on it yet because we're recording ahead of when it happened, but you guys, you get the joke.
Yes. On that note, I think our last episode, we had talked about an upcoming Supreme Court case on which cert might be granted. That was going to be this episode, except cert was not granted, so there's nothing to talk about.
So now it's uninteresting.
Instead, well, one other thing I want to mention is we now have a new recording set up. Kirk and I are leaned over, staring at each other across the table with our fancy new Audio-Technica microphones, a Focusrite Scarlett 2i2 audio interface, and my busted old gaming laptop. So we're still messing with volumes and stuff, so if you get some oddities in terms of the volume changing here and there, it's just us getting used to these new microphones and playing with the settings. So just bear with us while we kind of figure that out and try and get this new setup working. Hopefully, though, the audio sounds cleaner and crisper and less echoey.
For fans of the show, you know, when we did this when we first started off, we all had essentially professional microphones that we were used to using. So this is kind of returning back to our roots, and it's a little bit easier in many respects.
Yeah, although the microphones they had were a little more forgiving than
they were a little more forgiving than these are. I mean, they also we were in a sound room and everything else. So
today we're going to talk about something else, not the Supreme Court case. We're going to talk about the lawsuit that Disney and Universal Studios recently filed against Midjourney, one of probably the biggest lawsuits to be filed in the ongoing AI battles. This one's remarkable for a couple of reasons, not least of which is who the plaintiffs are, two of the largest content-producing companies in the world.
Yeah, and I think the two largest animation studios in the world. I mean, there may be some debate as to exactly who's bigger and stuff like that, but definitely two of the most well-known.
Yeah, for sure, and we'll talk about that more in a second. Well, let's go into that now. I mean, Disney, obviously, they own Star Wars, they own Marvel, they own Pixar, and they own Disney, so that's a lot of animation and content
and National
right
Geographic,
there.
But that doesn't really matter for this.
Well, and Fox, we have the Family
Fox.
Guy and
Simpsons.
The Simpsons are in there too, so there's a lot there. And then Disney Universal has all the Universal animated stuff. I forget what their animation studio is called.
DreamWorks.
DreamWorks, yeah, but that's Minions and Shrek and Boss Baby and Kung Fu Panda and all kinds of... There's a lot here.
There's also a lot of major properties in Universal that you think of as not necessarily animated properties. I mean, Fast and the Furious is in Universal. Universal Monsters, which I know people don't talk about as much, but they own a lot of the monsters. So, yeah.
Monsters, Inc. What's Pixar, isn't
That's Pixar.
Yeah, okay. Anyway, so they are your plaintiffs. They are suing Midjourney, and we're going to talk about this case for a couple of reasons. One is that it's kind of weird that this is being filed now. Midjourney's been around for a while. But before that, we're going to get into the basis of the copyright allegations because this has been reported in the media as one of the first cases where the claims are over infringement of character copyright, one of our favorite topics.
Yeah, but those of you who are longtime fans of the show, you'll know. I mean, character copyright is one of the things I love to talk about. I find it kind of fascinating, and I think it's interesting because there is no real character copyright. This is kind of a creation of the courts.
Definitely, and we had a request from a listener to kind of dig into that in a little more detail and kind of build up the Law School 101. How does this all work? Which, as Kirk and I were going through it, we're like, it's not actually all that clear where this is in the Copyright Act, but that's typical. So let's talk about that.
Having written a paper about character copyright, in particular character copyright in locations, I can say it's not at all clear where exactly character copyright comes from.
Yeah, that's a whole separate topic. Kirk, when I was an intern here at the firm, Kirk had me help him with his paper on universe copyright, which is a whole separate, complicated mess.
But it's essentially treating the setting as a character in and of itself. So can I say that something that is a setting or a location. So, for example, Tatooine or Hoth or Hogwarts, which is the one I specifically used, are those characters under the character copyright because they're settings, they're locations.
If you want more on that, go listen to our very first episode, which is about the Rogue One trailer when it came out and how you could write a story set in Star Wars. Could you avoid all of the actual IP? Now, we know from Battle at Axanar, that's harder to do than maybe it sounds like, but anyway, so let's talk about it. As we've been through before, the Copyright Act. Let's back up. Copyright's in the Constitution. It's weirdly, it was there at the beginning. The Bill of Rights was not. Copyright was.
Yep.
And it comes from a British tradition, the Statute of Anne, from the early 18th century,
17 something,
17 aughts, I think. Very old idea that basically authors, not publishers, should own the copyrights in what they produce.
And a lot of it came out of sort of modern publishing and the sort of the ability to actually reproduce at scale. So we're really talking like Gutenberg printing press and sort of early stuff around that.
Yeah, it's an interesting historical thing that when the printing press was invented, as you can imagine, the crown immediately said, yeah, that's mine now, and you can only print what I say is okay to print. As you can imagine, very little was printed that was critical of the crown or the church.
Yeah.
So Queen Anne, to her infinite credit, said, well, that's a bad idea. Why don't we change that and let people print what they want? And that idea was incorporated into the Constitution, and we are now in our third iteration of the Copyright Act.
Yeah, basically.
Passed in the 1970s. It's a little long in the tooth now, but it is what we have. So it lays out what you can copyright, and what you can copyright is not everything. It gives a couple of categories, and Kirk and I will look at, we won't go through and read them all, but the bottom line is none of the categories of things you can copyright includes expressly characters.
Yeah. I mean, it's really focused when we say about, what the categories are. It's things like books, movies, audiovisual works, music, things like that. And characters are things that kind of cross the genres that are talked about, but also aren't really discussed within it because they're not really accurate as to what it is. I mean, I can't have a character. I mean, a character does something in a book. I can't say there's a character that exists outside of a story in which the character exists. But we acknowledge the fact that there's this character copyright, the specific copyright in characters. And this is a relatively recent creation. I mean, it's what it is. It had a little bit of a weird start in the way they sort of created it, but in some sense, it's a creation of the courts. Where it does come out of is the potential for creation of derivative works. That's I think generally accepted as to what it is, but it's also in the fact that you can have copyrights in components of a work.
Yeah.
So just because you have a copyright in a motion picture doesn't mean somebody can copy, a third of it because that's not the entire movie. No, you can have copyrights in portions so long as they have sufficient expression to sort of be recognizable. And there's this essentially recognition that a character is sufficiently recognizable when it becomes sufficiently attached to the story.
And it's not always, and we're going to talk about this in more detail, certain types of works are more amenable to this sort of protection than others. So let's look at the list real quick. If you're playing along at home, it's in 17 USC section 102, lists the types of things that are protected. The first category is literary works, books, novels, stuff like that.
Poets.
So obviously characters can exist in books. The second one is musical works, including any accompanying words. You know who came to mind immediately when I thought of this is Earl from that, was it the Dixie
Goodbye
Chicks
Earl,
song?
yeah, Goodbye Earl.
Okay, I mean, that's a character.
It's interesting, but the one I jumped to mind was Pinball Wizard. But
Pinball Wizard's a good one, yeah. Yeah, that's, the Wall, the Pink Floyd double album is kind of about a character. So, you can have characters in these things. Queen Strikes, Mindcrime, Operation Mindcrime is sort of another one like that. So these concept albums have that. Dramatic works, including music, so your scripts basically for plays and stuff.
Plays,
obviously
musicals,
characters. Pantomime and choreographic works, it's dance. That might be
It also covers,
tougher.
I believe that covers puppetry as well,
Okay.
I think, if I remember correctly. But yeah, choreographic works, pantomimes. I mean, pantomimes, so you're going to say, a visual work with no wording. I mean, or no spoken words.
Yeah, it's more body movement. But we did an episode on this, and it's much narrower than just dance.
Yeah.
And so I think it'd be tough to, not impossible, I think it'd be tough to establish character in that.
Yeah, you can definitely have scenarios where it would be, an example of a place where I could see it potentially arriving is something like the background characters in Lion King.
Yeah.
The stage version of Lion King, where they're costumes in some respects.
What about
we're getting away,
though? Like the Nutcracker or like a Black Swan?
Yeah, maybe. Yeah, maybe? Black Swan's not a bad idea, actually. Yeah, the Swan Lake, technically,
Swan
let's be
Lake,
accurate.
Yeah. I'm thinking of
the movie.
Yeah.
The Natalie Portman movie.
Next category, pictorial, graphic, and sculptural works. Obviously, you can have characters in...
David.
Undoubtedly,
that's a biblical character, but
he's public domain now. Motion pictures and other audiovisual works, video games, things like that, obviously character. Sound recordings. I'm thinking here of the War of the Worlds radio broadcast. I know it's based on a book, but you have character there. People do acting on radio programs and things like that.
Yeah, good way to maybe radio dramas, things like that. Or, you could even have sort of voice acting would be another possibility. So I'm thinking, when we sort of say sound recordings, I could have, for example, just a voice actor with no associated video. That could potentially be something that I think you could also say has a character in it.
We get that with podcasts now. There's dramatic podcasts and stuff.
Radio drama, again, I think is a good way to put it.
And then architectural work, probably not. But
probably not.
Wouldn't rule it out. Okay, so obviously it can be everywhere. It can be any one of these things. What's interesting is that the character, as we say, the character per se is not protected under the idea-expression dichotomy. Copyright protects the particular expression of an idea, not the idea itself.
Oftentimes the way to think about it is it's basically, in the way they talk about in character copyright, is the character sufficiently unique, or is it an archetype? So the example of like things that I tend to use is I can write a work that involves a emo Danish prince, but I can't use Hamlet.
Right.
So that's, the kind of thing that you get into is what does it mean to say the character is an archetype versus being a specific version of the archetype that you have with it? So again, you kind of look at it and say, hey, I have the idea of the crusading hero. Well, you have no idea who I'm talking about. I could be talking about hundreds of different characters. I could talk about the star-crossed lovers. Well, that's Romeo and Juliet, but you have no idea which ones I'm actually talking about. I can still make Titanic. I can still make And so when you talk about the idea of the archetype, the hard-bitten detective, hard-boiled detectives, ones we've talked about, are film noir detective. Interesting enough, I think film noir is one of those places that you really actually see the archetype become the closest to being its own character.
Well, and James Bond too, I'd say, is like that. Like what you think of as an archetype for like a spy drama is basically anything that was in James Bond at this point.
Well, in some sense, we've talked about this previously in episodes. What is a tree man? Well, it's an ent from the Hobbit,
or it's a tree ant from Dungeons and Dragons.
But you get into a lot of these things where you kind of have these archetypes that get created. Another great example that they actually bumped into is effectively the superhero, and I don't mean the superhero generically. I mean the superhero being Superman, because that's the original superhero. And there is a case having to do with whether or not the essentially concept of Superman is a general concept or a specific character. It had to do with the TV show Greatest American Hero, which, if you know it from, that was in the 80s. He was basically a bumbling version of Superman. And the thing behind it is that there was a lawsuit as to whether or not that infringed Superman, or whether Superman was effectively an archetype. That's a lot of one of the cases that really gets into this concept of like, what does it mean to be an archetype versus what does it mean to be an actual character?
Let's talk about how the Copyright Office views this, because to sue anybody for stealing your character, you have to first register your character with the Copyright Office. I can tell you from a hard-won experience that if you file a registration and you say, I want a copyright on this character, they will tell you no, it's not eligible for protection. If you're playing along at home, you can Google this, Copyright Compendium, section 313.4, subparagraph H, characters, says directly that you cannot get copyright coverage of the character per se. The copyright in the character is limited to the artistic rendition of the character in visual form or the literary delineation of the character's specific attributes in textual form. Trademark law may separately apply. See your trademark attorney for those details.
And let's be clear about this. We're only going to talk about copyright law here.
Yeah.
There is trademark in a lot of these characters.
Bag of worms.
We've even gotten into it. We want to do it in the Public Domain Day episode with regards to Mickey Mouse, and the idea of Mickey Mouse being a trademark in addition to being a copyright. But we're going to solely talk about copyright here, and that's because there is no trademark assertion in this lawsuit. It's at least as far as I know.
I didn't look for that, but probably not.
Yeah, this is a copyright suit. So what we're talking about here is copyright and copyright law.
So we should say it's interesting that it says the literary delineation, because not all characters, even if depicted, get this kind of protection. The character has to be, which is weird, it's a kind of a trademark thing. The character has to be distinctive enough that you could say that there's enough original expression to protect it. So if I just have a generic Nazi footman character in my World War II novel, that doesn't stop anybody else from also having a stock Nazi footman character. I'm not infringing your copyright by doing that. That that's not eligible under various theories. Sans faire might be one, or it's just simply not sufficiently delineated. It's an obligatory element.
It's where you also get an archetype, and the questions around archetype, what does it mean to be an archetype? So again, you're talking about essentially, a foot soldier, around this. Hey, you can't necessarily get into that. If I want to say, it's a Nazi soldier, it's a SS soldier, those are more specific, but they're still generic archetypes that you would sort of get into with this. Great examples of ones that you could get into. How about a zombie? I mean, a zombie is a generic archetype, though obviously there are more specific zombies in specific movies. We can think about how the zombies in, for example, 28 Days Later are quite a bit different than those in Day of the Dead or Night of the Living Dead. They're different styles, they're different things that come into there.
That's a good idea, the idea-expression dichotomy. No one owns the idea of a zombie, but there's a million ways to portray a zombie and how they come to be and how they work.
One of the best ones is a vampire, or even to be more particular, Dracula. Now, Dracula's in the public domain. He's old enough that he's basically in the public domain. But, if I say, how do you depict Dracula, there's lots of different ways to depict Dracula. There's Nosferatu as Dracula. There's, Helsing, as Dracula.
Van Helsing,
Van Helsing.
Hotel Transylvania, the comedic Adam Sandler version.
Yeah, you can have comedic Draculas. You can have very, very gruesome Draculas. You can have very...
You have your vampire Lestat. You have what's the other one that was really popular a couple years ago? The one that takes place in Seattle where they all sparkle.
Oh, Twilight.
Twilight, yes. Yes, there's lots of ways to do that. And so it's interesting because the protection itself, what you can actually claim a copyright on, is somewhat narrow, but what can be deemed to infringe is actually a little bit broader. And this kind of goes to Kirk's paper. What exactly are you infringing in the character? It has to be that expression, but if I'm drawing an entirely new, let's just say I'm sitting at home and I want to do my own fan art version of Darth Vader, definitely a distinct character, right?
Yeah.
If I just sit down and draw my own picture of Darth Vader, it's entirely original. It's from my own imagination. Yeah, it looks like him, but I didn't sit down and copy anything directly. What have I infringed?
Well, and that's, I think, the problem you get into with this is what is Darth Vader, and we talked about the fact, and I think we mentioned it in the show, not just another thing beforehand, you can't necessarily copyright the character's name. You have to copyright the character's expression.
Let's assume he's in the suit, right? The iconic black suit. He's carrying a lightsaber. It's unmistakable.
And so in some sense, you're copyrighting the suit, the visual depiction of him and his personality. And you've got James Earl Jones' voice that will always be Darth Vader, as we all know. Interesting enough, involving AI. But it's one of those things where, what really is Darth Vader? And so you can kind of look at it and say, well, Darth Vader is an archetype. Arguably he is the rigid enforcer, kind of the tormented,
your SS
guy.
footman.
Yeah, he's your SS footman. Kind of the reason we started there. And things like that. But he's also a very specific, unquestionably specific character, and we all know exactly who we mean when we say Darth Vader because of the black suit, the way the black suit is, and everything else associated with that. So what exactly do we mean when we say Darth Vader? And that's...
Yeah, along those lines, speaking of the SS footman, so even though we have, say, a visual depiction in the comic book of, say, a Nazi footman, is that different from a Star Wars stormtrooper?
Yeah. And again, these are specific costumes, but this was actually what my paper got into, is when does it come into it? And interestingly enough, there's also a dichotomy between the visual appearance of a character and the written appearance. So, and that's where a lot of this thing comes into, is that one of the original cases involving character copyright involved the character of Sam Spade and his literary depiction versus his depiction in the movie. In film, and whether or not they could infringe, and they were ruled that they couldn't, because the literary depiction could never be specific enough to actually show something that would be visually portrayed.
Which we now know is not really the correct
rule. And there's a lot of indication that case may have been badly decided and just never been overturned. But an example of a later one had to do with, for any of you guys who may have seen the show, a lawsuit over a presentation of a proposed script. The script involved a bunch of characters who were Vietnam veterans going out and trying to essentially save and help people, and described each of the characters in depth as to what the details of them were, and some of their stuff, so their personalities. For example, I believe one of them didn't like to fly, was one aspect of their personality. The nature of the sort of colonel, I think it was, that led them was an aspect of what it was. And the issue with it was, I just described the A-Team, but the person was not the writer of the A-Team. It had actually been a script that had been proposed a couple of years earlier.
Cargo, right?
It's Cargo.
Yeah.
And so the issue you bump into in conjunction with it is, who's the A-Team? Well, Vietnam veterans, going out and helping people seems like archetypes.
or an idea.
Or an
least.
idea.
It's not a character.
But when do you get to them being sufficiently delineated, and that's the term that you sort of talk about, to being specific characters as being, Mr. T's depiction, of the character in the A-Team, who, is his inability to fly is the desire to fly is an important aspect of a lot of episodes. It's a very, very interesting place to go into because you have trouble saying what is the character, but we acknowledge the fact that there's copyright in the character. Now, some characters are a lot more iconic, and Vader's a perfect example,
Yoda.
What it is, Yoda. Whereas you get into something like a Stormtrooper, it becomes a little less, sort of clear because it's by definition a generic character, but it's also a specific generic character.
Yeah, there's not a Stormtrooper, there's millions of them, but they all look the same and they all look very distinct.
But then you sort of stick with Star Wars. What do we then get into? Okay, well, what's an Imperial officer? They're basically just wearing a jumpsuit and have a sort of like colored name badge.
What about the vehicles? Like, isn't an AT-AT Walker is highly distinctive?
Yeah.
Is that... can I copy that or not? Is that a character? Or is
We
that
talked about that one previously, too.
At the Batmobile.
I'll give you a really specific example, having just watched Andor. How about the random guys Andor encounters in episodes 1 and 2? Mm-hmm. Are those clearly Star Wars characters? They're essentially shipwrecked individuals wearing ragged clothes.
In a jungle, yeah.
In a jungle, is that a specific character or is that an archetype?
Well, I think, so turning to the lawsuit, Kirk and I both noticed something right away in the lawsuit. We'll try and link to this in the show notes if I remember. But the lawsuit itself is full of pictures showing the original depiction of the characters and the output from Midjourney and showing how they are similar. And there's really whatever is protected, there's no doubt here that it's been copied, right? Like, it's impossible to deny.
It's very, very clear from looking at these things that this is Darth Vader. This is Yoda. This is a minion, is an example.
What's interesting is what they chose to highlight. In almost all cases, we're only showing either animated characters or human characters or alien characters, I suppose, but people in costumes. I don't think there's...
Or serious prosthetics.
Yeah. There's really no situation here where it's just an actor portraying a character where the face is clearly unambiguously visible.
There's kind of one for Luke Skywalker.
We'll get to that, yeah.
And a few of those...
So we have Minions, How to Train Your Dragon, the animated version, Stormtroopers, Shrek, WALL-E. I'm just scrolling through here looking for some
Lightning
of these.
McQueen, I know, is one of the ones
we saw.
Lightning
McQueen was in here. Yoda, Stormtroopers, the droids, R2-D2 and C-3PO, Chewbacca. But
Mandalorian.
They don't give us Princess Leia, Luke Skywalker, not even Emperor Palpatine. So it's all situations where we can't get
or even to be like
up.
even little things. Cy Snoodles, who's a relatively like unknown character, but I think most people know who Cy Snoodles is.
If you saw her, you'd know who she is. The Simpsons, we've got Marvel characters, but they're all in masks. We've got Iron Man in the costume. We've got Deadpool in the costume. Spider-Man in the costume. Groot. So you get the idea.
Yeah, and the animated characters, Hulk, Rocket Raccoon.
And we suspect the reason for this is to avoid having the copyright issues get tangled up in right-of publicity and other types of issues, because the way the actor appears is just a fact, right? And we don't want to have, if you're a plaintiff in this lawsuit, you don't want to be arguing about, well, this is just what Robert Downey Jr. looks like.
Yeah, exactly. We're not talking about Robert Downey Jr., we're talking about Iron Man.
Iron Man, the character. So we think that's deliberate. Now, interestingly, there is one spot, though, where they show a generated output from Midjourney, and it does look like Mark Hamill playing Luke Skywalker. But we think that's because they're illustrating that the data was trained on Star Wars, because the prompt they put in was something like man in robes with light sword, movie quality.
Yeah, being specifically movie, sort of give us a movie frame showing.
And even with that generic input, it produced what looks exactly like Mark Hamill with the lightsaber. So anyway, that's an interesting fact. So this is not a terribly nuanced situation in terms of, well, we can't really tell if it's really Star Wars or not.
Yeah.
I don't know about you, Kirk. I really don't have a whole lot of doubt on this one.
Yeah, to me, looking at this thing, there is little question. This is Darth Vader. These are minions. This is Lightning McQueen. And part of it also is it's not like it's also just Darth Vader. There's probably 50 characters discussing in conjunction with this. All of whom are reproduced very sort of, accurately, I guess might be a good way to put it.
But which is to say, whatever Midjourney's defense here is going to be, it's probably not going to be non-infringement. It's probably going to be fair use or DMCA or something like that.
Or lack of copyrightability. And again, the idea of actually challenging the copyrightability of characters, which is not an unreasonable position. It's a difficult one, but it's not an unreasonable position.
I just think they're going to have trouble saying these aren't somehow derivative works. It's going to be more nuanced along the lines of, well, we didn't infringe. These are based on user prompts, and it wasn't us generating this. It was this machine over here. Go blame the machine.
Yeah.
Now, I don't find that terribly persuasive personally. We have a body of law for this. If you take a dog and you train it to attack people and it attacks people, you're responsible for what you trained it to do.
Yep.
Okay. And here we have a machine that was trained to produce, based on copyrighted works, outputs that look like those works. I just don't know how you get out of that.
This is one of the things we've talked about a couple times, that both of us give presentations regularly in other areas about AI and sort of legal things around AI.
We just did one in Minneapolis.
Yep. And one of the things you bump into with that is that there's kind of a distinction between the work the AI generates and what the AI does. In this, we're talking about the output. This is unquestionably the output of Midjourney.
Yes.
We're not talking about what is Midjourney doing internally, what was it trained on. We're talking about what is its output.
And that may be the defense, is that, because this is a new area of law, and it's definitely not unreasonable to argue that the company is not ultimately responsible, at least for direct infringement, any more than if they had hired an independent contractor to do this. If you're the user and you ask for something, then that's it's a sort of separate analysis. But it may be that there's some nuances in the theories of secondary liability that aren't very well fleshed out, and that's where they're going to rest their non-infringement case. Not that the outputs don't copy, they seem to clearly copy, but that for nuanced legal reasons, Midjourney as a company is not responsible for it.
Yeah, we sort of get into the question, and this is who is copying.
Yeah.
The idea is, yes, the machine is ultimately generating the copy, but Midjourney is not controlling the machine at the time it's making the copy, but the end user is also not necessarily telling it exactly what output to produce. And I think that's sort of to your movie frame issue. Yeah. I didn't say make a Jedi with a green lightsaber, use a bunch of terms that would clearly be referencing Star Wars. It was, man with light sword. Yeah. Now, admittedly, light sword is kind of the generic way everybody says lightsaber, but they do have a light foil or something like that instead of a saber. But
they do have an example in here of saying, "Give me Darth Vader doing whatever," and it will generate Darth Vader. So it clearly knows how to do that. The argument may be on the fair use side that, in terms of what Midjourney's doing, maybe it's copying, maybe it's producing a derivative work. But just like if I sat down and drew a picture for my own personal use, that might be a copy. But that by itself, what's the harm? What are the damages? How is that an is it a fair use? Is it transformative? Well, I think I'm using a small part. Is it a commercial substitute, etc.?
And this is a little bit where we bump into the issue with character copyright, because you can look at it and say, assuming there is a copyright in the character, that's an infringement. Even if it's for personal use, you can't sort of get away with the idea that, no, it's minimalist, it's anything along those lines, it's an infringement.
Those are more fair use arguments.
They're fair use arguments. And the problem you get into is a lot of the fair use is, we talked about this in sort of our prior fair use episode. How much of the work did you take? Those kind of questions. What's the commercial impact of it? Well, if I'm doing this individually in my house and I'm drawing it to hang on my own wall, those questions all kind of come down to zero. And so, but there's an issue of, okay, that sounds like a fair use, but there's also a practical reality of just being sued over it.
Yeah, who's going to know, right?
About it. Yeah. But when you get into something like this, it's okay. Yes, there's each individual one of these but there are hundreds of millions of these.
Yeah.
And they're not all being produced by individuals. They're being produced by one company's machine. And so those are the kind of things where it gets, okay, it feels like we're moving away from fair use, as a potential defense. It's commercial. There's no question it's commercial. And so but where does that line lie?
But I think the interesting question, so we talked about this before with fair use. Let's go through the 4 factors real quick.
Yeah, we should actually.
Purpose and character of the use. And there's this false dichotomy in the statute. Is it for commercial purposes or educational nonprofit use?
Yep.
Well, you can have commercial nonprofit or educational, and nonprofit can also be commercial. So it's a fake dichotomy. But that's where the transformativeness thing turns up. Is the new use transformative of the original? And that has 2 parts. Is it a transformative work in that you transform the original work? or is it a transformative use in that we're using it in a transformative way? That's kind of the Warhol thing.
Yeah,
but
Warhol definitely go listen to our Warhol case if you want to get into those elements, because that's what that episode is entirely about.
So there's an argument here about transformativeness, which is a nuanced and difficult and hard to predict. But that if you win on transformativeness, you usually also win on fair use.
Yeah.
The second factor is nature of the infringed work. Is it entitled to a high degree of protection? These obviously all are.
I mean, these are major screenplays, major property. This is, I think, zero question in my mind. These are entitled to
that
serious
factor almost never plays any role unless you're Google. The third factor is the amount taken. Now, this is where it's interesting because for all of these, I mean, how much content is there depicting Darth Vader?
So this is the piece that I'm really getting into, because it's, if you said, okay, well, how much Darth Vader is there in Star Wars? Well, not very much. But at the same time, how much Darth Vader is there in Darth Vader? Because the character is what we're talking about. Well, Darth Vader is Darth Vader. It's 100% of the character.
He took the entire character, right?
Yeah, so we may take 1% of the movie, but we take 100% of the character. And that's the important thing to sort of recognize, with the idea that the courts have said, yes, there's copyright in character, even though you can't kind of directly register it, because now your fair use thing says, no, you've taken the character, or all, the aspects of the character. So now we're looking at, like, what aspects of the character do you take? So again, like, if I took Darth Vader and said, yeah, but his pants aren't quite exactly the same number of folds, okay, you still took most of him, and stuff like that. But if you said, okay, the only thing I took is that I have, a character in black wearing a helmet, but, his helmet looks nothing like it. It looks sort of like, Alien from Aliens. Okay, that's probably not Darth Vader.
Yeah. Well, here's a good example of that. They recently announced an upcoming sequel to one of the greatest films ever made, Spaceballs. Okay, I don't know if that's an authorized or licensed knockoff. I don't think it is. But Dark Helmet is clearly Darth Vader, but he's also not. The suit is not the same. He's
incredibly short.
Rick Moranis is very short. The helmet is absurdly oversized. He's wearing a necktie. I mean, it's just ridiculous.
Yeah, and that's, when you get it, that's also clearly a parody. Now, keep in mind, parody is not a defense to a commercial use. That's one of the things people sort of get into. The parody in copyright law means a critique, really. You have to be parodying in order to critique.
I'd argue that is what they're doing. They're making fun of Star Wars throughout the entire thing.
But, and it's, I don't know if those are licensed. My guess, quite frankly, would probably be they are. That they probably do something with this.
I wouldn't be surprised either way. It's one of those cases where, as long as the parody is well done, nobody cares.
There is that issue, and also, again, this is a big movie. These are big movie studios. They have almost certainly sorted this out amongst themselves, even if there is no formal agreement. Everybody knows what's going to happen. They're not going to spend the money to make the movie unless they know what's going to happen.
I saw the greatest comment I've seen on Spaceballs 2 so far. One, Mel Brooks has to reprise his role as yogurt, and if there's not a baby yogurt named Gogurt, we all riot.
But it has to be in a tube, right? Instead of in his little pod, he has to be in a tube.
Yes. I've now forgotten where we are after that diatribe. Oh, fair use factors.
Fair use factors.
Okay, so amount taken is up. This is kind of like the Google case. Like, did you take 100% of the API or 1% of the overall programming language? Did you take 100% of Darth Vader or 1% of all of Star Wars?
And that's where I think when you really get into it there, and again, to sort of reiterate the point I made earlier, we're talking about a character copyright, which means you can be 100% of Darth Vader. You can say that. Now, I think there is a challenge that can be said, the fact that the character copyright really shouldn't be valid in a character at all. That's an uphill battle and probably a losing argument, but I do think there's a legitimate argument it's not in the statute.
You could game this. You could just file a registration on like a still photo of Vader and say, okay, well, here's just a photo of Vader by himself on like a white background, and your Vader is taking all of this Vader. I mean, that's an easy way to get around that. This is one of those other things going to fall out of the analysis almost entirely and boil down to it's going to come out whichever way the case does.
Yeah.
The last factor is usually the most decisive, and that is the effect of the new use or work on the market for the original. And if I'm Midjourney, this is where I hammer it and say, people producing fan art, basically using our engine, are not making a market. You're not going to not go watch Andor because we've made a stormtrooper using Midjourney.
Yeah, and that's, I think, a very intriguing idea with it, because in some sense, we have had fan films for years. People have always, people have cosplayed Star Wars since Star Wars.
Yes. One of the first things you do when you're learning how to use a rotoscope or do special effects is go animate a lightsaber battle.
Yeah.
Everybody, you can find a million of them on YouTube.
Yeah, and so I think now, admittedly, there's some educational stuff there, which you can also potentially get into. Yes. But one of the things that you really get into with this is what is the market of this on the original, and the whole idea being, hey, this is all fan art, there's no market. The problem with it is, I'm not sure that's true. Because in today's day and age and sort of the internet economy, the attention economy, anybody who posts anything on YouTube and is attracting clicks is arguably a commercial entity.
So this is where if I'm Midjourney, I say, yeah, but Midjourney's not posting anything on YouTube. That's what our users are doing downstream. Yep. Your defendant is that user over there and his YouTube channel.
Of course, at the same time, then I can also pop into it and say, as Midjourney, you are unquestionably commercial because you are selling assets to Midjourney.
This is where the secondary theories of liability get in, where you have vicarious and contributory and all those kind of things, which we're not going to get into because they're complicated. But once you start to tease this out, the argument for fair use on the output side becomes a little less frivolous.
Yeah, it's not a completely frivolous thing, but I think you get really into 2 points. One of which is a transformative, and the second, how do we get into this market? Because these people are not copying Empire Strikes Back by making copies of the digital or the film reel and stuff like that. They are making things which are not stories, or if they are stories, they're not stories that are, anything Disney arguably owns. And so what we're talking about with this is characters and what can you do with those characters. The problem with it is that you sort of never copy the story when you copy a character. And again, this is one of those things when I did this paper, way back when, I found very interesting because I'm purposely not copying the story. What if I take Darth Vader and I put him in an entirely original story? I've copied none of the story elements, which granted him his copyright in the first place. But I copied him, but I can't copy his name. There's no copyright ability in his name. But what if I just say, and this being sort of the example, if I write a book and just say Darth Vader shows up. I haven't described him. It's a literary work. I have no imagery of him. Now, you know who Darth Vader is, but again, you can't protect just Darth Vader's name as a character.
As a thought exercise, suppose we wrote an entirely different story. It takes place in 14th century Bavaria about a villager who is trying to survive off of beets. And the character's name is Darth Vader. That sounds kind of Germanic, doesn't it?
Yeah, exactly.
So is that an infringement of this character? Probably not, right? We'd say, no, probably not. It's a coincidence. It's some type of weird satire or something, but probably not a copyright infringement at least. But what if we start layering in story elements where the character used to be known as Anakin?
Yeah, well, let me get into sort of as we start getting into those ideas of story elements. What if I take it and I'm going to take my Darth Vader who's living on beats, and I'm going to have him end up with a fight with an intergalactic predator.
Yes.
And I do say predator with an emphasis, but I don't describe that character in any way. We just know it's somebody who's a big game hunter that's going to come down.
Capital P or lowercase p.
Yeah, it's going to come and fight with, our Darth Vader in the beats. And, we describe him as kind of animalistic, but we don't really say as to whatever it is. But clearly it's an intelligent species.
Mm-hmm. Collecting trophies of some kind, perhaps?
Collecting trophies, sort of things. Am I not starting to describe some properties? And, wait, there are comic books that explore stuff like this. They get into it. I mean, anybody wants to go ahead and find, Predator versus Aliens versus Superman. Yes, it does exist.
Well, how about this? What if I want to make a movie about a killer man-eating shark?
Yep.
That's just an idea, right? Nobody owns that idea for that movie.
Yep.
If I call the shark Jaws, is it now a character copyright infringement, or is it just a trademark infringement, or is it neither of those?
Yeah. What if when there's also a character Jaws in James Bond, the guy who has the ability to bite through anything. He basically has bad, nasty braces, and he can bite through metal and stuff like that. His name is Jaws. But isn't that the same character? No, it's a totally different character.
Course, yeah. So these things get weird. And then, like a final thought exercise on this topic. Suppose I draw a picture of a generic man in robes, not carrying a lightsaber, but man in desert-style robes, a la Episode 4 Tatooine. Yeah. Does not look at all like Hayden Christensen. It's just a guy, and I just label it Anakin Skywalker.
Yeah, it happens to be Lawrence of Arabia.
Yeah.
Maybe Lawrence of Anakin.
Is that an infringement? I mean, so these doctrines are messy and unclear and not really explored all that well in law, because these kind of weird fact patterns don't usually get acted upon.
And I think this is one of the things that AI is really kind of forcing us to look at, because it's, you could have something along these lines, but it wasn't really that accurate. It wasn't really that common. We have both a commonality and a high degree of technical accuracy. I mean, and again, I think that's the thing when you look at these imagery in this filing, these are unquestionably Darth Vader. That's unquestionably what's shown here.
There's no cute arguments to make here that it's not really Darth Vader.
Yeah, I mean,
so it's going to be
frankly, in some of these, you can't tell which one's the real one.
Yeah, we have to look and see side by side which ones are which. So one thing we kind of talked about before we started recording is one of the things that's interesting about this is, why is this lawsuit being filed now? And why has Midjourney not turned any of this ability off? You can't do this with Claude or ChatGPT.
Yeah, Claude specifically says I can't generate stuff like this.
I had trouble getting ChatGPT to give me Popeye, who's public domain now. So let's talk about that. Why now? And we've speculated that it might have to do with an ongoing dispute with the various talent guilds in LA over the use of AI, and that the studios didn't feel comfortable filing a lawsuit challenging the use of AI until they had their own house in order.
Yeah, remember, I mean, the studios also want to use AI. I mean, my understanding is there is an agreement with James Earl Jones and Disney where Disney is entitled to use his voice forever as Darth Vader using AI. He's done samples. He's done now. That was obviously a negotiated, I presume quite well compensated license that both parties unquestionably agreed to.
I'm sure Mr. Jones's heirs will enjoy the largesse of that agreement for some time to come.
Yeah, exactly. And I can't fault either party for making that agreement.
No, that's how it should be done,
it's supposed to be done.
It's an iconic voice. It's his voice. It's his performance. He and his kids and grandkids, and probably great grandkids at this point. How old is he? He's got to be in his 90s. Deserve to be compensated. That's fine.
Yeah, and again, there's no reason for them not to do this, and you understand why Disney would do it. So it's one of those things where there's that type of thing where I think there's a lot of just figuring out what is the rule. What are we saying is the appropriate way to do this? And again, I would look at it and say I think that is unquestionably the appropriate way to do this. But then it's when we start at the appropriate, when do we get to inappropriate as we move away from that? And I think that's part of the thing here is just the studio is figuring out how are we using this technology? How are they using the what if we use this technology to help us write a movie, but it also happens to look a whole lot like somebody else's plot? What does that mean?
We also speculated that perhaps part of this is that there was ongoing negotiation in the background with Disney and Universal and probably others looking to license these properties for them to use. The parties maybe being unable to come to agreement on that. Maybe it involved arguments over past damages and how much they wanted. So there may be a lot, and then maybe in the lawsuit, this lawsuit's 1hund15 pages long. We didn't read the whole thing. We just looked at the
pictures.
There's
also appears to be quite a bit of sort of expert analysis that went on. So, I mean, I think they also spent quite a bit of time researching this to see what the systems would point out.
And maybe waiting to see how the law develops and wait for those Copyright Office reports to come out. Does this kind of further arm themselves? It may have just been a matter of the timing being right.
Yep. I think there also is potentially the fact that, and one I think is particularly interesting, is the fact that Universal included the animated How to Train Your Dragon, knowing the live action is coming.
Yes. The live action animated.
Yeah, the live action animated movie. And you also have the same thing happening.
The dragon looks exactly the same. It's like a scene for scene remake.
You also have the same thing having to do with Mandalorian and Grogu, movie coming. So, it's something where the properties in some sense are sort of firing back up again. You got to know the whole new Marvel series coming, with the Doomsday and things like that. So it's, now, not to say that there aren't always these kind of movies and properties coming down. So there's always going to be something coming.
That's about all that goes into theaters anymore is previous IP.
Yeah, though there's definitely new animation. I mean, Pixar just released a brand new movie, if I remember correctly. And so, it's interesting to see, what is the timing. So I think there may be some aspect of commercially it also makes the right time. But I'm not sure commercially there's a wrong time for this kind of thing. I think that's also sort of worth pointing out.
So why would Midjourney not turn all this off? I mean, the obvious answer is people love to do this, and that's what you're paying for. So why make your product crappier?
But let's face it, we also have the stuff where, like, the things which you can do now, the style of Studio Ghibli, things like that. We've got...
Well, that's also a lawsuit.
That's also a lawsuit. Though that is ChatGPT, right? That's not...
I forget, but I know I've gotten ChatGPT to do in the style of before, but the style of is not normally protected.
That's debatable.
But I mean, it's not, right? If you ask the Copyright Office, they'll say no, it's not, and it shouldn't be. But how is that like? If you do it in the style of The Simpsons, what does in the style of mean other than copying the expression?
Yeah, well, the problem here is The Simpsons. It's, how do you make somebody in the style of The Simpsons without inadvertently making a Simpsons character that already exists?
That's tough. So there's some interesting questions here. This is obviously at the earliest stages, and we'll see what happens with it. But this is a big one. This is sort of a sea change and a different type of case than what we've seen before. A lot of the other lawsuits have been filed by authors over books and their output. Getty over the use of photography.
Which I believe that case is currently happening while we're talking about it. So we may be
There's
talking
a UK
about
version that's
UK
running
version,
ahead of the version here. So there's a lot going on. This one, though, boy, the The complaint looks good for Disney, if I'm being honest. It's the side-by-side images are really effective. But as we said, as you talk through the defenses, though, you can see why, if you're Midjourney, you might be a little reluctant to just rush off to settle if you think you've got plausible defenses.
Yeah, I think you can definitely say if you're Midjourney, there's a viable defense here. Whether or not it's winning is another issue entirely. But a lot of this is, very frankly, probably a business decision on both of the parts of both of these entities as to whether or not this lawsuit makes sense to have at it right now. Whether or not a settlement will happen, I think there's a decent chance this case will settle. Just because a lot of them do. It would be interesting to see this go to trial, just because of the fact that it would be fascinating to see what a judge has to say, going through the episodes, and where does the analysis fall? Like we said, is this a fair use case? If it is a fair use case, which factor of fair use is going to become important? If this isn't a fair use case, is it whether or not these are is character copyright at all? Gee, I can see a court saying no, character copyright doesn't exist at all. I'm going to change the law and say it doesn't really exist at all. It has to be something associated with the individual work. You never know where something's going to go. And so I think that's part of the issue, is where do we potentially have this? What it would be interesting to see a judge and where do they go? And again, especially an appeals court that has a little bit more specialized knowledge.
The Ninth Circuit, which is one of our better copyright courts.
Getting a hold of it and sort of saying, no, let's actually decide what happens here. And again, unfortunately, the odds are probably against it going to court. Most cases just don't. But it might. We have two large defendants that each have entrenched interests, and those are the kind of cases that do go to court.
It's weird. Sometimes when there's a lot of money involved, it helps settlement, and sometimes it doesn't.
Yeah.
And obviously we're not privy to any of the stuff behind the scenes. None of these are companies that we work with, but it's not as clear cut maybe as it looks like, and maybe that's the ultimate point of this, is even though the complaint looks pretty devastating for Disney and NBC, there are still defenses, and the law is not entirely clear.
Well,
and
the defendants have not filed their brief yet, have they?
No, this got filed on June 11th, so there's plenty of time for Midjourney to respond.
And maybe we'll do an episode talking about Midjourney's brief when it comes down.
Yeah, we didn't talk about the DMCA. They may argue, because they are hosting like a gallery of content. They might be able to argue DMCA. I don't think that's probably a winner, because DMCA requires like user uploaded stuff that you don't know is there. How can you not know? Like what your platform's generating. But we'll see. Midjourney, I don't know who their lawyers are going to be, but they're going to get good lawyers and they're going to make good arguments.
Yeah.
And these things are almost never as clear cut as they maybe seem at first.
Yeah, and I think that's the thing. And again, we might do a podcast on their sort of brief and response and talking through, hey, here's what they say. That might be a good episode in the future. Obviously, if people want us to do that, let us know.
Yeah, for sure. All right. Well, I think we've covered that one. We'll keep you guys up to date on what happens with this, and then, like I said, we're going to keep trying to get content out to you on a weekly basis. Sometimes it'll be like this, where it's kind of what's going on now stuff, and sometimes it'll be more evergreen content. So we will keep that going. That's all for this time. We'll see you next time. Lorem, play us out.
The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by Lewis Rice LLC, its officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer. This podcast was produced and recorded in St. Louis, Missouri.